Just as Judge William Alsup leaned back in his chair, a faint smirk spread across his face while Congresswoman Jasmine Crockett approached the witness stand in the packed federal courthouse. Only minutes earlier, he had waved off her legal argument with a casual flick of his hand, dismissing it as the kind of amateur reasoning I'd expect from a first-year law student. A stunned gasp rippled through the gallery at the federal judge's unusually sharp rebuke of the black congresswoman and former public defender. The smirk on Alsup's face seemed to say it all. He believed his decades on the bench made him untouchable. But the next few minutes would leave the entire courtroom speechless and could forever change how Americans view judicial overreach. Crockett tightened her grip on her legal pad, her eyes locked on the 78-year-old judge like a laser. She didn't flinch. This wasn't just another hearing. It was about to become a masterclass in confronting judicial arrogance. Before we return to this extraordinary moment, remember to hit like and subscribe so you never miss our latest political showdowns and real-time justice. Now, back to the federal courthouse in Washington, D.C., where history was quietly about to be made. The ornate courtroom buzzed with tension that morning. High ceilings, dark wood paneling, and a press gallery jammed with reporters armed with notebooks and cameras gave the space a sense of charged anticipation. This wasn't a routine motion hearing, it was a high-stakes case on voting rights, an issue tearing at the fabric of American politics. Judge William Alsup, appointed by President Clinton in 1999, had long been known as a no-nonsense jurist. Silver-haired and sharp-eyed, he cultivated an air of authority few dared to challenge. His resume included landmark rulings on Google, Uber, and constitutional privacy disputes. Lawyers called him brilliant. Critics nicknamed him the smirking judge for his habit of offering a knowing half-grin when he thought an argument was weak. In recent years, however, observers noticed a tilt. His patience with progressive legal claims was thinning, especially when presented by younger attorneys or women of color. Voting rights advocates worried that his rulings were drifting steadily rightward. Facing him that day was Congresswoman Jasmine Crockett of Texas's 30th District. At 42, she was relatively new to Capitol Hill but hardly new to the law. Before running for office, she had built a formidable reputation as a civil rights attorney and public defender, earning the nickname the Giant Slayer for dismantling powerful opponents with surgical legal precision. Crockett wasn't merely attending as a spectator. She had filed an amicus brief and been granted time to speak because of her seat on the House Judiciary Committee and her deep interest in a case that could affect voting access for millions of Americans. The stakes were enormous. The outcome would determine whether new state-level voting restrictions, widely criticized as suppressive, would survive federal scrutiny. If Alsup ruled in favor of the restrictions, countless voters, particularly in minority and rural communities, could face new barriers in the upcoming election. Civil rights groups called it the most consequential voting rights case in a generation. The confrontation had been brewing since the day before. During preliminary arguments, Alsup had repeatedly interrupted female attorneys while allowing male counterparts to speak at length. When Crockett's team presented data on voter disenfranchisement, the judge visibly rolled his eyes and muttered, something that reporters in the front row caught as typical exaggeration. Whispers circulated that Alsup had privately questioned why a freshman congresswoman should be allowed to address his court at all. He granted Crockett time only after pressure from higher courts. As Crockett approached the podium, the tension was electric. Alsup initially refused even to look up from his papers, a clear signal of disregard. When he finally raised his eyes, the trademark smirk appeared, the same one that had rattled countless attorneys. But Crockett was no ordinary lawyer. She had faced hostile judges in Texas, battled systemic racism, and now stood armed with both her congressional authority and years of courtroom experience. "Your Honor," she began, voice steady but resonant, "before I address the legal merits, I must express concern about your characterization of our arguments yesterday." Alsup leaned forward, smirk widening. "Congresswoman, this is my courtroom. I've been interpreting constitutional law since before you passed the bar. If you have actual arguments, get to them. Spare me the lecture." The courtroom fell silent. The battle lines were drawn. "With all due respect, Your Honor, Crockett replied, her voice gaining strength. "I passed the bar after studying the same Constitution you did. That document doesn't change based on how long one has been interpreting it." A low murmur swept through the gallery. Alsup's smirk faltered, just briefly, before returning. "Congresswoman Crockett," he said, "may I remind you that in this courtroom, I am the final authority on constitutional interpretation." "Your political office grants you no special expertise," Crockett's eyes flashed. "I'm not here as a politician today, Your Honor. I'm here as an attorney representing the millions of voters who stand to be disenfranchised if these restrictions remain." Alsup tapped his gavel lightly. "The potential impact is precisely the matter before this court. Your assumption of disenfranchisement presupposes the conclusion we are here to decide." "Then let's examine the evidence," Crockett shot back. She opened a folder. "May I present the statistical analysis your court interrupted yesterday?" "You may proceed," Alsup said with a dismissive wave, "though I note for the record that statistics can be manipulated to support virtually any position." The remark drew raised eyebrows from civil rights attorneys in the gallery. Crockett took a deliberate breath and began laying out data showing how the new voting restrictions disproportionately affected minority communities, rural voters, and the elderly. Each citation was crisp, each exhibit numbered. Alsup tried to interject. "These numbers don't account for alternative voting methods," he challenged. "Actually, Your Honor," Crockett countered smoothly, "page 17 of our brief provides a comprehensive analysis of all voting methods impacted by these restrictions." Alsup frowned, flipping through the documents with growing irritation. "And what about the state's interest in preventing fraud?" he pressed. "I was just coming to that," Crockett replied, directing the court to Exhibit C, an exhaustive chart showing fewer than 30 verified instances of voter fraud in 20 years out of millions of ballots cast. These negligible cases cannot justify measures that will disenfranchise hundreds of thousands of legitimate voters. Alsup shifted uncomfortably. "The legislature has a duty to be proactive, a duty that must be balanced against the constitutional right to vote. And the judiciary," Crockett shot back, "has a duty to scrutinize laws that infringe on those rights, not defer to them. I'm well aware of judicial review. Congresswoman, then you are also aware of the Supreme Court's decision in Harper v. Virginia Board of Elections, which held that wealth or fee-paying has no relation to voting qualifications." "Harper concerned poll taxes," Alsup retorted. "These measures are about verification. Verification that functions as a poll tax when voters must pay for documentation or travel long distances at personal cost," Crockett replied without missing a beat. "The effect is the same, even if the mechanism differs," legal reporters scribbled furiously. This was no longer a routine hearing. It was becoming a landmark constitutional showdown. Alsup attempted to reassert control. "While your passion is admirable, this court needs legal arguments, not emotional appeals about voting rights." The dismissal landed like a thunderclap. Crockett paused, then smiled faintly. "Your Honor, it's remarkable that when male attorneys argue constitutional rights around the Second Amendment or corporate speech, it's considered scholarly. Yet when a black woman argues for voting rights, the very foundation of our democracy, it's labeled emotional." Gasps echoed through the courtroom. No one had ever addressed the judge's potential bias so directly. Alsup's smirk vanished, replaced by a hard glare. "I advise you to tread carefully when questioning this court's impartiality." "I'm not questioning," Crockett replied calmly. "I'm observing a pattern that's relevant to these proceedings. And since we're discussing the nature of arguments before this court, allow me to introduce additional context." She nodded to her aide, who handed over a document. "This is a transcript from Shelby County versus Holder, where Your Honor stated, and I quote, 'Times have changed, and the extraordinary measures once necessary may no longer be needed.'" The room froze. Reporters leaned forward. Crockett continued, "That statement was used to justify weakening the Voting Rights Act, and today, the very measures you suggested were no longer needed are being weaponized to restrict the vote once again." Alsup opened his mouth, then closed it. The smirk was gone. Crockett pressed on, her tone measured but unyielding. The Constitution is not a relic for selective interpretation. It is a living guarantee that no citizen's right to vote shall be abridged. We stand here not for abstract theory, but for millions of Americans whose voices hang in the balance. The chamber sat in stunned silence. Even veteran reporters later admitted they had rarely witnessed a federal judge so thoroughly and so publicly challenged. Alsup, long feared for his cutting intellect, now looked unsettled, flipping papers with no clear retort. Yet the data we've presented today shows that voter suppression hasn't disappeared, it's evolved. Judge William Alsup's face tightened, his smirk flickering for the first time. "Now, Congresswoman, you're taking my words out of context," he said sharply. "Then please provide the context, Your Honor," Jasmine Crockett replied, her voice steady but cutting. "Because from where millions of voters stand, it appears the judiciary is retreating from protecting voting rights, precisely when new forms of suppression are emerging." The judge tapped his gavel harder than before. Bang. "This court will take a 15-minute recess." Without another word, he rose abruptly and strode to his chambers, robe billowing behind him. The courtroom erupted in whispers as the door shut. Legal experts exchanged stunned glances. Reporters began typing furiously on their phones, knowing the confrontation they had just witnessed would make headlines nationwide. A federal judge walking out mid-argument was rare. Walking out because a congresswoman had cornered him. That was unprecedented. At the podium, Crockett remained composed, eyes scanning her notes. Her team approached, offering quiet congratulations for standing her ground, but she shook her head. "This isn't over," she whispered. The real battle was still ahead. When Alsup returned exactly 15 minutes later, the atmosphere had shifted. The smirk was gone, replaced by a cold, determined stare. He looked every bit the veteran judge ready to reassert control. "Congresswoman Crockett," he began, voice edged with steel. "Before the recess, you made some rather bold claims about judicial bias. I remind you that respect for this court is not optional." Crockett inclined her head respectfully. "I have the utmost respect for this court as an institution." "Your Honor, that's precisely why I believe we must address these critical issues openly." "Then address the legal merits, not perceived attitudes," Alsup countered. "Very well," she replied, turning a crisp page in her notes. "Let's discuss Crawford v. Marion County Election Board, where the Supreme Court upheld Indiana's voter ID law." A flicker of satisfaction crossed the judge's face. "Finally, precedent. As Your Honor knows," Crockett continued, "that ruling hinged on the state demonstrating a legitimate interest while proving the burden on voters was not severe." She paused deliberately, locking eyes with him. "However, the court also emphasized that its ruling was specific to the factual record in that case, and our factual record here is substantially different." She launched into a meticulous breakdown, distinguishing the current restrictions from Crawford. These new laws, she explained, were far more burdensome and surgically targeted to specific demographics. "Each point landed cleanly. That's speculation." "Congresswoman," Alsup interrupted. "Actually, Your Honor, it's statistical evidence gathered using methods previously accepted by this very court. The state has provided countering evidence that has been thoroughly rebutted by 3 independent expert witnesses." "Your Honor," she replied without hesitation. Each time the judge tried to cut her off, Crockett parried with precise facts. Slowly, almost imperceptibly, the balance of power in the room shifted. The judge who usually dominated his courtroom now found himself repeatedly countered by the Congresswoman's preparation and composure. Then came the moment that electrified the room. Alsup, growing frustrated, leaned forward. "Congresswoman, perhaps in the political arena, these kinds of emotional appeals about voter suppression win applause. But this is a court of law, not a campaign rally. I need you to stick to the relevant legal standards, not convenient narratives about voter disenfranchisement." The phrase "convenient narrative" sent a shockwave through the gallery. Civil rights attorneys visibly stiffened. Reporters looked up from their laptops. Crockett stood perfectly still, her expression revealing a flash of disbelief before settling into calm resolve. "Your Honor," she said quietly, her voice carrying to every corner of the packed courtroom. Did you just characterize the systematic exclusion of American citizens from their constitutional right to vote as a convenient narrative? The question hung in the air like a live wire. Alsup blinked, realizing the danger. I was referring to the characterization of these verification procedures as suppression, which is a legal conclusion not yet established, he said carefully. With respect, Your Honor, Crockett pressed. You specifically dismissed concerns about voter disenfranchisement as emotional appeals and convenient narratives. That dismissal itself reveals a prejudgment about the merits of our case, and it raises serious questions about whether litigants advocating for voting rights can receive fair consideration in this court. An audible gasp swept the room. Few attorneys ever challenged a federal judge so directly, and almost none did it in such a high-profile case. Alsup's face flushed crimson. Congresswoman Crockett, you are very close to contempt of court. The tension spiked. Every spectator held their breath. Would she retreat? Instead, Crockett slowly reached into her briefcase and withdrew a small, worn book. She held it up so that even the reporters in the back row could see the faded cover. Your Honor, I carry this pocket constitution everywhere I go. She flipped it open with deliberate care. The 15th Amendment states that the right to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The protection of this right is not a convenient narrative. It is the explicit text of our Constitution. She placed the Constitution gently on the podium. If defending that text places me in contempt of this court, she continued, her voice now almost a whisper, then I am prepared to face those consequences. The courtroom froze. No one moved. Even the air seemed to hold its breath. Alsup, realizing he had boxed himself in, sat silent for several beats. Following through on the threat of contempt would only validate Crockett's point. Finally, he cleared his throat. Let's proceed with your legal arguments, Congresswoman, he said, his voice noticeably less forceful than before. Round one had clearly gone to Crockett, but the day was far from over. As the afternoon session began, the judge attempted to regain momentum. Congresswoman, you've made provocative claims about the intent behind these voting measures, he said. But as you know, discriminatory intent must be proven, not merely asserted. I'm glad you raised the question of intent, Your Honor, Crockett replied with a measured nod. She gestured to an aide who approached with a sealed folder. What I'm about to present was obtained through discovery in a parallel state case. These documents have been under seal, but the state court lifted the confidentiality order this morning. Alsup's brow furrowed. This court has not had the opportunity to review these materials. That's correct, Your Honor. They became available at 9:15 this morning. We've prepared copies for the court and opposing counsel. As clerks distributed the documents, murmurs rippled through the gallery. Crockett continued evenly. These are internal emails and planning documents from the offices of the state legislators who drafted the voting restrictions now before this court. The state's lead attorney shot to his feet. We object to the introduction of these documents. They were not included in the Congresswoman's amicus brief. They weren't available when the brief was filed, Crockett countered calmly. But they are directly relevant to the question of intent, precisely the issue Your Honor just raised. Alsup began scanning the first pages, his expression tightening with each line. What exactly are you alleging these documents show? Crockett's eyes gleamed with quiet resolve. That the legislators who drafted these laws specifically targeted what they themselves called demographic challenges to their political power. Gasps echoed across the courtroom. She laid out the bombshell, evidence with surgical precision, detailed analyses of voting patterns by race, age, and economic status, internal memos identifying methods of voting predominantly used by minority communities, explicit plans to tailor restrictions to suppress those methods. One email stated bluntly, if we can reduce turnout in these 5 urban districts by just 3%, we maintain control indefinitely. Another referred to historically, black colleges and universities as opposition voter, factories and strategized how to invalidate, student IDs for voting while keeping gun licenses acceptable. Each document landed like a hammer blow, Reporters frantically typed. Civil rights attorneys exchanged glances of vindication. The state's lawyers whispered urgently among themselves, their confidence visibly crumbling. These documents, if authenticated, raise serious questions about legislative intent, Alsup finally admitted, his earlier bravado replaced by a tone of measured concern. They have been authenticated. Your Honor, Crockett replied without missing a beat. The state court ruled on that question this morning. The metadata and electronic signatures are intact. These came directly from the legislators' official accounts. She let the weight of her next words settle over the room. But what's most troubling isn't merely the explicit targeting of minority voters. It's the knowledge that these measures would not survive judicial scrutiny if their true purpose were revealed. Crockett held up one final email. This message from the Speaker of the House to the bill sponsors states, and I quote, "Frame everything around election security. Never mention demographic impacts in writing. Remember, we need neutral justifications for the courts. The impact was immediate and undeniable." This was not only evidence of discriminatory intent, it was proof of a deliberate attempt to deceive the very court in which they now stood. The judge sat in silence, absorbing the implications. The gallery remained frozen, every ear tuned to the next words from the bench. "These documents," Alsup said at last, his voice softer, "will require careful consideration." But Crockett wasn't finished. She connected the revelations back to the morning's confrontation. Your Honor, earlier today you characterized concerns about voter disenfranchisement as emotional appeals and convenient narratives. These documents demonstrate why such skepticism is dangerous. When courts begin from a position of disbelief, they enable precisely the kind of deception these legislators attempted. They counted on judicial skepticism. They believed that if they provided a neutral pretext, courts wouldn't look deeper. They were banking on judges who would dismiss discrimination claims as mere narratives. The parallel to Alsup's own words hung heavy in the room. The judge who had started the day dismissing Crockett with a smirk now faced the uncomfortable truth that his own skepticism had nearly played into the legislators' strategy. The state's attorneys tried to mount a defense, arguing the emails were out of context or reflected only a few individuals' views. Their objections crumbled when Crockett directed the court to yet another email explicitly listing AA turnout, African American turnout, as a problem area to address. By late afternoon, it was clear the hearing had transformed. What began as a routine challenge to voting restrictions had become an exposé of intentional discrimination and judicial complacency. Then came the closing moment no one would forget. Judge Alsup, still reviewing the damning documents, raised his hand for silence. The courtroom fell instantly quiet. "Congresswoman Crockett," he began, his voice markedly different from the commanding tone he had used hours earlier. "When you began your presentation today, I was skeptical of your position. I believed you were bringing political rhetoric into my courtroom. I questioned whether your concerns about voter suppression were exaggerated." He paused, choosing his next words with care. "These documents suggest I was wrong." A collective gasp swept through the chamber. Reporters captured the words in real time. The smirking judge who had dismissed Crockett that morning had just admitted on the record that her evidence had changed his mind. Federal judges almost never admit error, certainly not in open court, but this hearing would become an unforgettable exception. The evidence Congresswoman Jasmine Crockett presented revealed not only that the state's new voting restrictions were deliberately designed with discriminatory intent, but also that their authors built a facade of neutrality to deceive the courts themselves. Judge William Alsup removed his glasses, rubbing the bridge of his nose in a rare display of humanity. "This court has a constitutional obligation to protect voting rights," he said gravely, "particularly when faced with evidence of intentional discrimination. I will be taking these documents under advisement and reconsidering my preliminary views on this case." Then, looking directly at Crockett, the smirk that had once lingered on his face was completely gone. "Congresswoman," he continued, "I owe you an apology for my earlier characterization of your arguments. You weren't being emotional or political. You were being a dedicated advocate for constitutional rights, exactly what our system requires." The courtroom erupted in murmurs. Crockett, ever professional, simply nodded. "Thank you, Your Honor," she replied. "The right to vote is fundamental to our democracy. When we fight for that right, we fight for the Constitution itself." Observers knew they had just witnessed a historic moment, a federal judge publicly acknowledging error, and a Congresswoman exposing not only voter suppression, but also the judicial attitudes that enable it. A shockwave across the nation. Within hours, news of the Crockett-Alsup confrontation spread nationwide. The hashtag #eCrockettBlowback began trending across social media. Legal blogs posted real-time analyses, calling it a watershed in voting rights litigation. CNN's legal analyst labeled it the most significant courtroom clash on voting rights since the Voting Rights Act. Challenges. MSNBC ran a primetime special titled How Congresswoman Crockett Changed the Game. Even Fox News covered the story, though they framed it as judicial independence under attack. Major outlets quickly published the leaked emails Crockett had introduced, with sensitive details redacted. The raw, blunt language shocked Americans who assumed explicit racial targeting was a relic of the past. One legislator's email read chillingly, "These communities only started voting in the last few elections. If they can't navigate some extra paperwork, maybe they're not committed enough to deserve a ballot." Public outrage was immediate. Civil rights organizations launched fresh challenges to similar laws in other states. Law schools announced they would add the hearing transcript to their civil rights curriculum. Inside the White House, senior advisors huddled to rethink the administration's voting rights strategy. "This changes everything," one official told the Washington Post. "Crockett just gave the country a roadmap for exposing what's really happening inside these state legislatures. The judge's own transformation for Judge Alsup. The professional consequences were profound. His public admission of error was virtually unprecedented. For a federal jurist of his stature, conservative, commentators accused him of caving to political pressure, while others praised his intellectual honesty. 3 days after the hearing, Alsup issued a preliminary injunction blocking the voting restrictions from taking effect until a full trial could be held. His 87-page opinion cited the very emails Crockett had presented, concluding that they revealed a clear pattern of intentional discrimination cloaked in pretextual concerns about election security. Most strikingly, Alsup addressed his own early skepticism. This court acknowledges that judicial skepticism toward claims of discrimination can itself become an unintended barrier to equal justice. Legal scholars called the statement extraordinary and potentially transformative for future voting rights. Cases, Crockett's rise for Jasmine Crockett, the aftermath brought both acclaim and new responsibilities. She became an overnight hero to voting rights advocates. Civil rights organizations sought her help in similar cases across the country. Law schools invited her to lecture on constitutional strategy. In a CNN interview a week later, Crockett reflected, "What happened in that courtroom wasn't about me or Judge Alsup. It was about whether our courts are willing to see what's happening to voting rights in America. For too long, judges have given the benefit of the doubt to restrictions that target minority voters. That day, we pulled back the curtain." When asked if she had been intimidated by Alsup's early dismissiveness, Crockett smiled. "I've faced skeptical judges my entire career. As a black woman attorney in Texas, I learned early that I had to be twice as prepared and twice as persuasive. But I also learned that the facts and the Constitution are powerful weapons when wielded correctly. Political fallout. The political consequences were swift and severe. State legislators implicated in the emails faced intense public scrutiny. 2 resigned within weeks. Others faced primary challenges inside their own party. The governor, eager to distance himself, ordered a sweeping review of the state's election procedures. The ripple effect spread far beyond state borders. Legislators in 3 other states withdrew similar voting bills. "No one wants to be the next email scandal," one representative admitted privately to the New York Times. Most importantly, Crockett's confrontation sparked a national conversation about judicial attitudes toward voting rights. Bar associations organized seminars on implicit bias in the courtroom. Law Reviews published special issues examining how judicial skepticism had shaped voting rights jurisprudence since Shelby County versus Holder. 6 months later, a survey of federal court decisions revealed a measurable increase in the success rate of voting rights challenges, a phenomenon legal analysts dubbed the Crockett effect. A new legal playbook in legal education, the confrontation quickly became a case study in effective advocacy. Professors highlighted Crockett's combination of meticulous preparation, moral clarity, and strategic timing. She didn't just win a case, wrote Yale law professor Heather Gerken. She changed how judges approach these cases by exposing the gap between neutral pretexts and discriminatory reality. For everyday citizens whose ballots were at risk, the victory was deeply personal. Community groups organized "Thank You, Congresswoman Crockett" rallies. Elderly voters sent handwritten letters describing how the challenged restrictions would have kept them from voting. The final ruling 1 year later, Crockett returned to Judge Allup's courtroom for the final ruling. The atmosphere was a world away from their tense first encounter. The once dismissive judge now treated her with evident respect. His decision permanently blocked the voting restrictions and ordered the state to submit any future changes to federal pre-clearance, effectively reviving a key protection of the Voting Rights Act that the Supreme Court had weakened in Shelby County. Legal experts hailed it as a groundbreaking decision likely headed for the Supreme Court. In a conclusion destined for constitutional law textbooks, Alsup wrote, "The right to vote is preservative of all other rights in a democracy. When that right is burdened by design rather than necessity, courts must intervene, not as political actors, but as guardians of constitutional principles. This court initially approached this case with unwarranted skepticism toward claims of voter suppression. That skepticism was corrected by evidence and advocacy of the highest caliber." Crockett's graceful triumph outside the courthouse. A reporter asked Crockett if she felt vindicated by the judge's complete reversal. "This was never about vindicating me," she replied. "It was about vindicating the Constitution and the millions of Americans whose votes were at risk." Judge Alsup showed real judicial courage by acknowledging his initial error and following where the evidence led. That's how our system is supposed to work. Pressed on how it felt to silence a judge who once smirked at her arguments, Crockett smiled softly. "I didn't silence Judge Alsup. The evidence did. The emails did. The Constitution did. I was just there to make sure they were heard." Her answer captured the very reason she had prevailed. She never made the fight personal. She stayed focused on constitutional principles and unassailable facts, even when facing dismissive treatment. A lasting legacy. The Crockett-Alsup confrontation will be remembered not just for its dramatic twists, but for how it reshaped voting rights litigation across America. It proved that when advocates are meticulously prepared and courageously persistent, even the most skeptical judges can be persuaded, and it reminded the nation that the right to vote, the foundation of all other rights, demands constant vigilance and fearless defense, as Crockett later told the Congressional Black Caucus. The struggle for voting rights didn't end with the 15th Amendment or the Voting Rights Act. It continues every day in every courtroom where these rights are challenged. And as long as there are those who seek to suppress votes, there must be those of us ready to stand and fight. The question now facing America is clear. Will other judges follow Allup's example of intellectual honesty when confronted with evidence of discrimination? Or will old patterns of judicial deference return?